Thank you for your attention. I will now turn it over to the presenters.
Thank you, Alicia. Hi, everybody. Good afternoon. This is Amy Chung from Asusta, and I'm here today with Gail Pendleton, our Executive Director.
Hi, everyone.
Thank you to everybody for joining us. This afternoon, we're going to be talking about administrative appeals, motions to reopen, and motions to reconsider before USCIS. And this presentation and our project is supported by the Office of Violence Against Women, and we thank OVW for their support of today's presentation. The structure for today's webinar is that first we'll be talking about some of the background and general process behind appeals, motions to reopen, and motions to reconsider. From there, we'll be covering some of the legal arguments that we see in some common issues. And then from there, we'll be getting into some of the strategic considerations that we would encourage people to think about as they are planning their appeals and motions. All right. And the objectives for today are that participants will be able to identify the options for administrative review following denial, that you'll be able to articulate these strategic considerations in choosing an administrative review option, so appeal, motion to reconsider, motion to reopen, and that you'll be able to identify the requirements for filing the request for administrative review. All right, so what happens when a case is denied? To start off, let's do a little bit of data collection. We always get a mixed audience with these webinars, so it would be really helpful if people could respond to these questions with either a yes or a no based on whether or not they have had a case denied by USCIS before. And of course, everything is completely anonymous, as always. Okay. So it looks like we have a quorum here. So it's a mixed bag, right? So yes and no. And for those of you who have had a case denied before, or even if you had any, perhaps had a case transferred to you, let's go to the next poll. How do we do this? There we go. So if you have filed an appeal or a motion to reopen or reconsider in the past with USCIS. Okay. So still a bit of a mixed bag, which is not surprising based on the prior poll. So it looks like we have some people who are very new to this and other people who might be old hats. If you have any questions, if you have experiences that you'd like to share with the group or with us, please put them into the chat during the presentation, and then we can discuss. It's always really helpful when people share their experiences from the field with us. All right, so let's go into some of the basic background information. So obviously, if we're talking about administrative review, there must have first been a denial, right? You wouldn't need to motion to reopen or reconsider or an appeal unless the service center had already denied your case. So step one in this process is that you're going to get a denial notice from the service center, most likely Vermont in these cases, but sometimes Nebraska or somewhere else. And in this denial notice, by regulation, they must explain to you the reasons for the denial, right? They're not allowed to just deny it without telling you why that is. And oftentimes, as you read this denial notice, that will start your thought process as to what your legal arguments are going to be to raise in your appeal or your motion. A couple other pointers are that it's possible that USCIS might have issued a request for evidence or a notice of intent to deny earlier on. Oftentimes if they did that, then that probably gave you an inkling of what the reasons for the denial might be. And if they did that, then you would have also had some kind of opportunity to respond to that. But starting in July, USCIS issued a memo on their new RFE policy which gave adjudicators much greater discretion to deny cases outright without having first issued an RFE or a NOID. So going forward, it's possible that you'll be receiving denial notices without ever having gotten an RFE or a NOID on that case.
And Amy, just to remind people that one of our jobs is to help you figure out how to reply even at the RFA and NOID stage. And I believe our previous webinar for grantees was on that. So if you weren't on that, you may want to take a listen to that. But we would encourage you to contact us sooner rather than later.
Yes, definitely. And then the other pointer here is that CIS, by regulation, should have provided your client with an opportunity to rebut any unknown derogatory information. Sometimes in the NOID, or sometimes for the first time you're seeing in the denial notice, that CIS is making some kind of allegations against your client, perhaps about criminal history, perhaps about gang allegations, whatever it is, that your client didn't know about, right? If they haven't already given your client an opportunity to rebut the information, then that's also potentially an argument for your appeal or for your motion coming up. So it's a really useful regulation to be aware of and to use to the extent that it's coming up in your cases. All right. So then what happens after your denial? So the most basic consequence of the denial is that your case is closed, right? Unless your appeal is filed timely. If your appeal is filed timely, then the case is actually technically still open until the appeal has been adjudicated. This can come in really handy, especially for U visa adjustment cases, because if your adjustment, your 485, is filed timely while your client is still in U status, then their U status is automatically extended until the 485 is adjudicated. And even if the 485 is denied, if you appeal it, then the 485 is technically still open, and your client would technically still be in U status and would retain work authorization. So this is a pretty specific scenario, but it has definitely come up, and so it's something to keep in mind when you're filing appeals. Another thing to keep in mind is that if you have filed an application where there were ancillary forms, then if one form was dependent on the approval of another form, then if one is denied, then the other is going to be denied as well, right? So, for example, if you have a 918 for a U principal with a 918A for the U derivative, if the principal is denied, then the derivative will also be denied, right? But the converse is not true. So if you have a 918A for a derivative that's denied, maybe you didn't have enough evidence to show the relationship to the principal, maybe there was a discretionary issue for the waiver, then even though the 918A is denied, that doesn't mean that the 918 for the principal will be denied, right? So ancillary forms can be denied, but only if they're dependent on the approval of the other form. Okay, moving on. Another consequence of getting a denial notice is that your client could be placed in removal proceedings. And of course, your client could be placed in proceedings before your client has even filed for relief. Your client could have been placed in proceedings while the application for the T or the U or the VAWA was pending. There are lots of times at which your client could be placed in removal proceedings. However, we bring this up because recently USCIS published a new policy memo in which they stated that all removable aliens, including those who have applied for VAWA, Ts, and Us, could be subject to the initiation of removal proceedings upon the denial of their case. And the memo went into a lot more detail about who is a high priority for removal proceedings, such as people with criminal history, a record of public benefits fraud, and things like that. But it did say that even if you don't have criminal history or public benefits fraud, that if you are not in status and your case has been denied and the appeals period has been exhausted, you could be placed into removal proceedings. And the slide deck was approved a couple weeks ago, and so we have a news flash. So the last bullet point on here that says that the memo is not in effect for humanitarian cases at this time, there's an update to that. The NTA memo will go into effect for humanitarian cases as of November 19th. So that's right around the corner. What we're asking the field is that if you start to see notices to appear being issued for clients whose VAWA T's and U's have been denied, that you let us know. This is something that we want to keep track of as it's happening. Right. And I'm sure for a lot of you this is old hat, but for anybody who isn't familiar with removal proceedings, when we refer to a notice to appear, what we're talking about is a specific form issued by the Department of Homeland Security on which DHS will explain the allegations and the charge of inadmissibility or deportability that they're making against your client. And it's the filing of the notice to appear with the immigration court that will initiate removal proceedings against your client. And at the stakeholder meeting back in September, after the issuance of the NTA memo, USCIS said that it's generally not going to issue these NTAs until the appeals or motions period has expired. But this is just a little background on that. The other thing that I'd like to point out is that there's going to be another stakeholder meeting on the NTA memo tomorrow, actually. And then I was going to put the link to this. Here we go. So if you are not already signed up for this stakeholder meeting, it could be helpful to attend to get the most up-to-date information straight from the horse's mouth as to the how this NTA memo is going to be implemented, because we don't actually have that information yet. All right. And then one other thing to keep in mind as you are getting notices to appear, as you're getting denial notices, is the protections at 8 U.S.C. 1367. Sometimes people refer to this as by shorthand as the VAWA confidentiality protections. We prefer using the whole statute just because confidentiality is just one small piece of the protections for VAWA's T's and U's. So, for example, if you are getting a denial notice where it looks like USCIS has obtained derogatory information from the abuser and is using it against your client, we would argue that that's a violation of 8 U.S.C. 1367. And even though protections against non-disclosure of confidential information end after all the appeals are exhausted, if they're using that to issue and a couple other things to keep in mind are that NTA, yeah.
You just cut out in that last sentence, so can you restate that, please?
Sure. Let me just check the closed caption to see where it cut off. Okay. So even though protections against the non-disclosure of confidential information ends after the appeals are exhausted, if USCIS was using information obtained from the abuser in the denial, then at the point when they were adjudicating your case, those protections at 8 U.S.C. 1367 were still in place, right? And so we would argue that using that abuser-provided information at that point is still a violation of the statute. A couple other points to keep in mind are that when you get the NTA, you should check it to make sure that DHS is not basing their determination of inadmissibility or deportability in the allegation section solely on information provided by the abuser or the abuser's household, because that protection continues even though the underlying application has been denied. And then if there was an immigration enforcement action that took place at a prohibited location under INA 239E, you'll want to check the NTA to make sure that that DHS has certified that they followed all of the procedures that are in place that are required when they're doing an enforcement action at a prohibited location. All right. And Gail, you're up.
So,
Gail, we're having a really hard time hearing you. No, you're still the same. Thank you everyone for your patience. We understand we're having audio issues and we're working to correct them right now. Nope, we still can't hear you. Can we try hanging you up and redialing in?
No? Okay.
Yeah, so we can't hear you at all. So just bear with us, everyone. We're going to get her reconnected.
Okay. In the meantime, I see that there are a couple questions in the chat box, so we can just get to those while Gail's signing back on. Okay, let's see. Does the 11/19 date refer to the date of application or the date of adjudication? So the 11/19 date is the date at which USCIS will start to enforce the NTA memo for humanitarian applications. We don't have any further clarification as to exactly what that means to previously filed applications. And so hopefully this will be clarified on the stakeholder call tomorrow. They were taking questions in advance, and so it's possible that you might still be able to submit those in advance. I'm actually not quite sure of the cutoff. Otherwise, there usually are opportunities to ask questions on the call during these stakeholder events. So another reason to sign up for the call tomorrow. I would anticipate that it refers to the date of adjudication. Okay, and then is there a link to this PowerPoint? It is it's in the files right below the chat box. It says Administrative Review Appeals and MTRs _final. So you should be able to download that.
So can you hear me now, Amy and others?
Yes.
Yes, I can hear you.
Okay. All right. Well, I'm just talking straight into my cell phone, so I hope that works. So you addressed the NTA question, and did you mention that question about the date was one of the ones we're asking them, which date is going to apply?
Yes.
Okay, great. And then I was starting to say, when the sound stopped working, is that those 8 U.S.C. 1367 arguments that Amy was discussing, we hope that we would work with you to identify those as they emerge earlier in the application, because probably by the time you get to an NTA, it's going to be a little too late for that. So again, this is to encourage you to get to us as soon as possible if you're getting kickbacks from the Vermont Service Center, the Nebraska Service Center, and for VAWAs at the local offices that seem like they maybe have other sources of information that we need to find out about. Okay, thanks for filling in for me while we got this thing sorted out. Amy, shall we move into the post-denial options section?
Yes.
Okay, great. Okay, so we already discussed briefly, you've got the appeal straight to the Administrative Appeals Office. You've got a motion to reopen or motion to reconsider at the Vermont Service Center. Obviously, once you've done an appeal to the AAO, if they deny, you could also do one of those motions to the AAO. And later on, we'll discuss if there are any options after that. All of those are going to be filed on the form I-290B, and all of those are going to be filed with Vermont with the fee or the fee waiver. And we're going to get into that fee waiver question in a minute because it is getting really complicated. And Amy, we were discussing this earlier. is that even though, say you got a denial from the Nebraska Service Center, you would still file the 290B with Vermont, right? But that they would then transfer it to Nebraska? Is that how it would work?
Yes. Yes.
Okay.
And you can also find the direct filing addresses for the I-290Bs on the USCIS website, which is what I would say is the most reliable and most up-to-date place to get the information on where to file the forms.
Right. But I think the bottom line is that Vermont is the gatekeeper, essentially, for all of this. Even if it's going to go to the AAO, it still goes through Vermont.
Yeah.
Okay. So here's a quick review of the arguments, and then we're going to run some hypos and get your thoughts and have some discussion on how you could use different arguments. Did the government properly apply the laws and the regulations? Did they properly address and apply the facts used applied to those laws and regulations? Just a footnote on the regulations, because I was recently doing some help on a case. Both the U visa regulations and the VAWA regulations are actually obsolete in some significant ways because the laws have been changed since those regulations are issued. So we have seen a rash of denials and RFEs coming out citing the wrong law. I think partly because they're looking at the old regulations. So definitely let us know if that's happening, because we want to raise that up to headquarters, that there needs to be some training on what the current law is on some of these issues. So then, do you have new evidence? That would go to a motion to reopen, as you probably know. Has the law changed? I guess is the idea on that the actual elements of the U visa and VAWA, or are you thinking more about like the procedural law on the guidance on NTAs and RFEs and things like that? Amy.
Well, sometimes there is actual substantive change to the law while a case has been pending. Sometimes there could be new case law that would influence the interpretation of something. Sometimes there have been changes to the statute, and so it's something to keep in mind as you are framing your arguments.
So perhaps an example of that would be that we had fairly recently a decision from the Administrative Appeals Office that appeared to agree with our argument that the U visa list of crimes are actually categories of crimes, not what the crimes have to be called. I don't know if you'd actually call that a change in the law, but I would say it's an elucidation of the law. So if you've been seeing denials where the Vermont doesn't seem to be understanding that, then you could use, for instance, that it's an unpublished decision, but it's still a very helpful decision as part of your motion to reconsider or an appeal to the AAO.
Yeah.
And
I think it also comes up quite a bit in the CRIM-IM context, where you're looking at changes, very frequent and circuit-by-circuit changes in interpretations of what's a CIMT, what's an aggravated felony, and things like that.
So where the applicability of that, especially for U visas, would be, as most of you know, you can't appeal the discretionary denial of a U visa waiver to the AAO, but you can appeal the misapplication of the law on whether a ground of inadmissibility has been triggered. So taking Amy's example, let's say the 11th Circuit has decided that a crime as applied to crimes of moral turpitude has changed. If Vermont is applying the old law, that's when you could do, that would be a motion to reconsider, right, because they're wrong on the law.
Yeah.
Okay. And then one of the key things here, which is one of the things you'll hear me say a lot, since some of you have heard me for 20 years talking, is that I think we're suggesting basically some massive paradigm shifts in how you approach these cases. And one of the paradigm shifts is, it used to be we thought that you could win most of your cases with your first application. So we weren't suggesting that you make a huge record or create a lot of legal arguments. Now we think this is more like when you're representing someone in immigration court, where you can't assume you're going to win at the first level. So you need to include in your record everything that you're going to want any jurisdiction above it to review. So that's why you're going to want to have all of the arguments, even if you don't think that the Vermont Service Center or the Nebraska Service Center is going to understand them. you're going to want to have those now in your applications or in response to RFEs or NOIDs if you filed these a long time ago and you're only getting those now, so that when you go to the AAO and perhaps beyond, that's in the record. So now we need to create records from the get-go in all of these cases. Okay, so let's run some hypotheticals. And perhaps those of you who have been doing this longer could chime in through the chat box so that your peers can see how you think this through. What's the error in this case? Vermont denies a VAWA self-petition for lack of showing battery or extreme cruelty. In their denial, they failed to mention several important pieces of evidence that you submitted to show battery or extreme cruelty, and they dismissed the rest of your evidence, which included your client's own declaration and what we would call a corroborating declaration from a domestic violence counselor. The reasons they said for that is that the client lacked credibility without a witness who actually saw the events, and they discredit the counselor's declaration because she also did not witness the abuse. What's the error in that? And I guess also if any of you have seen that, put that in the chat box. Just so you know, we used to see this at the beginning and we fixed it, but every like 10 years it comes up again, whenever there's new adjudicators. Okay, we see some folks typing. Okay, yes, Evangeline says she's seen this a long time ago. Evangeline, what do you think the error in that was? And Stephanie's also typing. The any credible evidence standard, Stephanie? Good point. So, Amy, you want to talk about what that means in this context? I think you're muted. Okay, and Evangeline's also saying there's no corroboration requirement. That is true. But Amy, what do you think? What would we suggest would be the best practice here, and how is the any credible evidence standard relevant to this problem?
So, as you guys know, the Congress allows VAWA self-petitioners and also TNU applicants, for that matter, to submit any credible evidence to support their applications. And so what this means is that USCIS can't require your client to submit primary or secondary evidence in order to support their case. And so when USCIS is saying that your client lacks credibility because there's no first-hand witness, and they discredit the corroborating declaration from the counselor just because the counselor didn't personally witness the abuse, that is a violation of the any credible evidence standard because they're requiring primary evidence here, which is not allowed. That said, because we know that USCIS does have a preference for systems evidence, we generally recommend that as a best practice, whenever possible, that you do provide systems evidence, right? That if there are first-hand witnesses, that you provide a declaration from those first-hand witnesses and things like that. But at the same time, Evangeline is right that you're not required to provide corroboration where it's not available. But you should explain why it's not available. You should explain what you've done to get it and why you can't get it.
Yes, and that's the paradigm generally for responding. On this particular issue, we had this conversation with them early on, and once they understood that, abusers' control of this and how the context of domestic violence is if you're a savvy abuser, you're not going to do it where people see you, right? That's very typical of abusers. So they agreed that their templates, because they do have templates that they send out, should not have that language in. That's a primary evidence template, as Amy said. So if you're seeing those, you need to raise those with us right away, because that's the kind of thing that they all agree they shouldn't be using, and we would want to let the heads of the unit know that some adjudicator has taken the template from like a regular family-based petition and is now applying it to VAWAs and use. That's the easy one. Let's move on to a little more difficult ones. Okay, so now Vermont has denied your VAWA self-petition because she failed to show good moral character. They say it's because she was convicted of a domestic violence misdemeanor that Vermont says is a crime of moral turpitude. You did, however, show that her conviction was connected to domestic violence. And perhaps some of you who aren't experts on immigration law but know about domestic violence could put in the chat why you think that would be true. Why would her conviction be connected to domestic violence? And this also explains why Congress amended the law to include this, connected to domestic violence exception for good moral character. Retaliation by the abuser, right. So the abusers go to court and say she's the one who really attacked me, or she may have fought back, right? And so she ends up getting convicted because she doesn't speak English or doesn't have a lawyer. There are all sorts of reasons why survivors may be convicted of crimes that are, in fact, related to being survivors of domestic violence. So what are the errors that you would argue here in this denial? And while people are thinking about this, what's the legal error here? You've all identified basically why Congress created this exception. What's the legal error that Vermont has committed in denying it for this reason? What are they failing to mention? So, Amy, I'm going to throw this to you since we're not getting any answers from
Yep.
from the
All
crowd.
right.
So,
the issue is that if you've been convicted of a CIM, if Vermont is right that this DV misdemeanor is a CIMT, and let's assume for the sake of argument in this hypo that it is. CIMTs generally are a bar to good moral character at INA 101F. But if you can show that it was connected to the domestic violence, there is a waiver available. And so Vermont, if they find that it's connected to domestic violence, and presumably you showed that this was connected to the DV, that they should be able to waive this and still find that your client has good moral character. And so if they didn't even address that argument, then that is a clear legal error and definitely the basis for an appeal.
And the one piece in here that isn't mentioned that I would suggest that you include if you're making these arguments that there's an exception to the good moral character requirement bars is point to the waiver that's available in the statute. Because Vermont isn't going to actually waive the crime of moral turpitude. They just have to see that there is a waiver. And do you happen to remember, Amy, what that waiver says for crimes of moral turpitude for VAWA self-petitioners?
It should be 212H.
Yeah, and as I recall, the waiver is just you are a VAWA self-petitioner, right?
Yeah.
I don't think waiver as you can get. Yeah. So if I were framing this, I would literally, because again, there are a lot of new adjudicators, so I'm not sure that, I think they've got a lot of adjudicators who come from other parts of the law and aren't familiar with the special VAWA laws. I would literally cut and paste from the statute the good moral character exception and the waiver at D14 and say, so this is what the law says. Yes, we will, let's say we concede that she has a crime of moral turpitude, but first of all, here's the waiver, so it is waivable. We're not asking you to waive it, but we're just pointing to that it is waivable, and here's the evidence that it is connected to domestic violence. That is their legal error here, is that they appear to be applying the normal 101F good moral character bars. Yes, right. So Evangeline asked, you don't actually need the waiver. No, which is why it is a little confusing, but the language in the statute actually says waivable, right? So all you have to do is point to the fact that there is a waiver in the statute that at the adjustment stage, if this was, say, a VAWA petition, they could use. And I suppose this is VAWA's, right? So I don't want to confuse people. Okay, so this would be an example, though. For instance, if you think they're wrong solely on their application of the law, which I would say is they're not even citing the wrong law, that's when you could do a motion to reconsider as opposed to a motion to reopen. Because you don't need to supply new facts. They're just wrong on the law. And they need to reconsider their inaccurate evaluation of the law. Okay. Now Vermont is denying your U visa application, the I-918, because your client has conviction for shoplifting, which they are construing as a crime of moral turpitude again. The facts, however, are, and this is where your crime of moral turpitude experts can think through this, it's only one conviction. The state shoplifting statute, the maximum possible penalty under it for this crime is less than a year, and there was no actual sentence or other deprivation of liberty for your client. Otherwise, your client is admissible. So let's assume for the moment that you didn't even file an I-192 here. Why would you not have had to file an I-192, which is essentially the same answer as what is wrong with their decision here? A petty offense exception. Evangeline, you get the star. Very good. So for those of you who aren't familiar, this has nothing to do really specifically with survivors. This is within the statute on inadmissibility for crimes of moral turpitude. And it's worth actually pulling the statute and taking a look at that section, 212A2. And just a reminder of a general legal principle is that if there's an exception, that means the ground doesn't apply at all. If there's a waiver, it means the ground applies, but you then have to ask for a waiver. So the reason you could decide not to even file an I-192 in this case is your argument is the crime of moral turpitude ground doesn't apply at all because the petty offense exception applies. Now, practically whether you want to do that, that's something we should talk to you about in some one-on-one TA. But that would be your legal argument. And that would be, obviously, I think, again, this would be a motion to reconsider because they're not applying the law correctly, although you could perhaps fashion it as a motion to reopen and a motion to reconsider, supplementing with more evidence that the petty offense exception applies. All right. Now, Vermont's denied your self-petition again, but this time for lack of good faith marriage based on them not having any children in common or any commingled finances. Says they can't find any text messages, emails, or social media correspondence that came from your client, between the two. How would you challenge this? This is a little different, I think. Partly, frankly, because good faith marriage, the definition isn't as statutorily based as it is seems to be kind of common law based and evolution of mores and some basic case law from the family system. So let's explore what you would normally supply to show good faith marriage in a VAWA self-petition. Why would you not have commingled finances necessarily if you're representing a survivor of domestic violence? And what other evidence would you show? Yes, abuser-controlled finances. So this is very similar to some of the other, for instance, that good moral character exception. This reflects the context of domestic violence, right? That the normal evidence that people would have if they were filing an application together as a family will not be available for most survivors because part of the power and control an abuser uses is the control of documents and putting people on traditional documents that you would use to show good faith marriage. So yes, the other problem here may be the short relationship. And one of the practice pointers on that is that you can look at the relationship before the marriage to show that it was a good faith marriage. The case law that Vermont Service Center seems to look at is a board case that was actually fixing a different problem. But there's a board case that says you should look at the inception of the marriage when they first entered the marriage to see if it was a good faith marriage. And then what happens afterwards could be just what happens in a regular marriage. That doesn't mean that it's not a good faith marriage. Vermont has kind of turned that on its head so that it seems like often all they look at is the intent at the time of marriage. I think that's wrong, but still you do want to focus on that. But and to do that, you actually want to show all of the steps that led up to that marriage. So in this, I think, is a case That's not so much they're wrong on the law, they're wrong on how they've applied your facts to the law, and that they're applying a primary evidence standard to the facts that they're insisting on. Although I actually have no idea what standard of text message or email or social media would fall under, but frankly, it's interesting that they're starting to look at that. So let's ask the question here, because this is actually where we're seeing, at least in the past, most of the VAWA self-petitions have been denied on good faith marriage. And I think a lot is very problematic because you can't use primary evidence. How many of you have had VAWA self-petitions either denied or received RFEs for this kind of problem, where they're saying that the evidence you've supplied, which is credible, still, in their view, doesn't meet your burden of showing good faith marriage? If you've had that, please type it in and we can share that with others. So, Amy, can you think of any other errors you would challenge in this? I mean, for those of you, while she turns on her mic, if you're seeing this, we actually have done 2 amicus briefs to the AAO on good faith marriage issues, and they're actually designed, and you can access our website for free, and they're available in Word form, because we put in there all of the legal arguments for why the way that they're reviewing your evidence violates the standards that apply in these cases. Often what you'll see is they'll go through each piece of evidence with a fine-tooth comb and tell you why that individual piece of evidence doesn't meet the standard, and then never talk about why, if you put it all together, it meets the standard. And so that's what we call a totality of the circumstances test. They tend to not apply that, and that is definitely the way they're supposed to be looking at that. So if none of you are having, oh, here's Stephanie. I responded to an RFE for a VAWA-based adjustment for primary evidence of good faith marriage. Okay, so Stephanie, if you have any other specific examples of how they were applying it, that would be helpful to share. These are, I mean, actually, usually what I see them say is having children in common actually doesn't show good faith marriage, frankly, so it'd be kind of strange to see where they expected that. And one of the practice pointers I learned from them when we were doing trainings together is that this is where the kind of what I call the gory detail declaration is really helpful. That giving, what is not helpful for them is declarations from your client and from others that say they loved each other or they were very loving couple. What they need is the day-to-day gory detail of how they lived a life together. And so one way I think that I suggest you check for this is you go through your declarations and essentially look at any sentences that have adjectives, adverbs, or opinions in them and see if you can turn all of those into facts and err on the side of supplying more facts than seems necessary so that they can hear in their own minds how this actually was a real life together, and it's not just someone's opinion about that. And this is as true for the corroborating declarations as it is for your own client's declaration. Okay. So Amy, if you unmic yourself and have any other suggestions, let me know. We'll move on to, in this denial notice for your VAWA self-petition, Vermont's alleging that your client never resided with her former spouse and that she paid him to marry her for immigration purposes. Let me just back up a second and highlight for you an actual system problem that we're seeing now. I've seen several cases where they've denied, saying that the residence had to occur during the abuse or during the marriage. That's just an inaccurate interpretation of the statute. That's not what the statute says. And that definitely contact us if you're seeing that, because that's basic statutory construction. We can teach you in another webinar how to do statutory construction, but they're basically glomming on an extra requirement for residence that is not in the statute. All the statute says is they have to have resided together. Since 2000, it hasn't required that they reside together in the United States. They just have to have resided together somewhere. So if they never resided together, that could be a problem. The second piece for the denial here is that she paid him to marry her for immigration purposes. They don't, however, tell you where they got that information from and you actually have no idea where it came from. So if I were you, I would suspect that this must have information came from the abuser, and what we actually have seen in the past is local offices that have contacted Vermont and said, we think, because they dealt with, say, an I-130 based petition by the abuser, they are basically acting as agents for the abuser in contacting Vermont and saying that they think this is a fraudulent marriage. What would you do about that? What would be the way to challenge that? Maybe, Amy, you could unmute yourself while these folks are thinking.
I see Maria is typing, so let's just give it a minute.
Right. We'll give you a clue. Remember that 8 U.S.C. 1367 we talked about? And we have actually used this in some cases. There hasn't been a whole lot of these, but this could start happening more, especially as the cases accelerate. If you think the information may have come from the abuser, what would you argue to them in response? And what would you ask for? Okay, she stopped typing, Amy, so why
All right. Let's pick it up here. Oh, okay. Here we go.
Yes.
So Maria says that it sounds like the abuser may have contacted the immigration office to try to retaliate against the victim, right? Where else would they have gotten this information, right? What is the basis for this allegation against your client, that she paid the abuser to marry her for immigration purposes? Okay, so this sounds like there could be a violation of 8 U.S.C. 1367, right, which prohibits the immigration agencies and various other federal agencies from communicating with anybody about your client who is protected as a VAWA self-petitioner. And so if Vermont has been communicating with the abuser, then we would say that that's a violation of the statute. And so, yep. Go ahead.
They're not allowed to use the piece that I actually call this. I know people often refer to this as a confidentiality provision. The piece that I think is really helpful here is what I call the evidentiary presumption provision, and it's interesting, you go back and look, there's a colloquy between Orrin Hatch and a Democratic senator at the time about why they were putting this in the law originally. And this, again, went back to the presumption that abusers lie, that they lie in order to harm their survivors. And so this is essentially a statutory presumption against evidence that comes from abusers and people associated with the abusers. And in fact, if the agency, and this also includes immigration judges, any employee of the Department of Justice or Department of Homeland Security in this case, who uses information, makes decisions on a case based solely on evidence from an abuser or someone connected to the abuser, could be subject to a $5,000 sanction, and definitely sanctions within the agency. And we have seen people sanctioned in the agency in the past, not at Vermont, but at local district offices, for basically seeking out information from abusers and using it. So in some ways we don't know, right? But I think that we need to aggressively use this provision to challenge apparent derogatory information that they're not sharing with you, right? Because that goes back to something Amy talked about. You have the right to know what the derogatory information is. Perhaps not the source and perhaps not all the details, but they can't just tell you, we have information that you don't know, and we're going to deny your case based on that. That's kind of a fundamental due process problem, right? This fundamental due process is you have notice of what the problem is and an opportunity to respond, and you can't respond when they don't tell you what the source is. So my suggestion is we start aggressively basically saying, we think this has to be a violation of 8 U.S.C. 1367, Vermont. You need to prove to us that it's not. And in fact, we might help you file a claim with the Civil Rights and Civil Liberties Division of the Department of Homeland Security on that kind of case. That's in the past where we've gotten some sanctions against people for using this information. And if nothing else, maybe we're wrong, but at least this should at least prompt them, given their possible sanctions, to tell you what the source of information actually is. And I think the other piece you can argue here is there's a reason Congress did this. Even if it isn't a literal violation, the reason they created this is you should assume that information of abusers is designed to harm the client. It's designed to use the immigration system against victims as a weapon of power and control. And Vermont, you should not have any part of that. And again, let us know if this happens, because this is the kind of thing we actually still will raise with headquarters in the Ombuds office if it's going on. Okay, so it's, as Maria says, often this is a form of retaliation. They find out that their survivors are actually trying to get status without them, and so they'll call up the immigration system and tell them that they married them just to get status. Okay, post-denial options. That's you, Rick.
I think this is back to me now. So here we're going to get into a little bit of the nitty-gritty for each of the three options: appeals, motions to reconsider, and motions to reopen. So for appeals, these are adjudicated by the Administrative Appeals Office, or AAO. As Gail mentioned earlier, you still file them on the Form I-290B. One really important thing to keep in mind is that you can't file both an appeal and a motion using the same form. You have to pick either an appeal or a motion. And we'll be talking about combining motions later on. Other things to keep in mind is that when the AAO looks at the appeal, it is de novo review. You can submit additional evidence because it's de novo review. They're not just reviewing the underlying decision for error. And then when the AAO adjudicates the appeal, they could sustain it and remand it back to the service center for a new decision. They could just go ahead and sustain the appeal and approve your case, or they could dismiss it, which is the same as denying. Okay. The other thing to keep in mind is, as I mentioned earlier, if you appeal timely, the underlying case does remain open pending the appeal decision, right? So the example I was talking about earlier was for U adjustments of status, which is where this really comes in handy, because your client is in U status and maintains their status during the pendency of the appeal of the denial of the adjustment. And they would also maintain their eligibility for work authorization as well. And then for appeals, there is sometimes an opportunity to get amicus support from outside organizations. And so we've done this in the past. And so if you have an appeal, as Gail had mentioned earlier, please let us know so we can help you think through some of the strategies and arguments to present to the AAO, and also so that if it's appropriate for an amicus, that we'll have time to help you with that as well.
Yeah, and we actually, it seems like they pay attention when we file amicus briefs. They may not always agree with us, but for instance, that category brief we spoke to, that got adjudicated much more quickly than many of the cases on appeal at the AAO. So there are a variety of reasons why you might want to work with us on that.
Great. All right, next up, motions to reopen. And so if you remember, for appeals, they're going to be adjudicated by the AAO, whereas a motion to reopen is going to be adjudicated by the office that issued the underlying denial. And so if your underlying denial was issued by Vermont, then Vermont is going to adjudicate the motion to reopen. And it's also filed on the 290B. This one cannot be combined with an appeal. You have to choose either a motion or an appeal, but you can combine a motion to reopen and a motion to reconsider, because you'll have a lot of cases where you have arguments that would support both reopening or reconsideration. For a motion to reopen, you do need to show new facts, but unlike the Board of Immigration Appeals, the AAO does not require that new facts be previously unavailable. So these could have been facts that you did have access to previously, but that you just didn't submit for whatever reason. And if you're submitting them anew now, then that could be the new facts that you would need to show for a motion to reopen. Another thing to keep in mind about motions is that the underlying case does remain closed unless and until the motion is granted. So this is also different from an appeal. And then
can I ask a question about that, Amy? Does that mean that we think that they, if once they implement the new notice to appear memo, that they might issue notices to appear against people who have filed motions to reopen or reconsider and have not filed an appeal?
From what I recall of the stakeholder call from September. They said that they wouldn't be issuing, their general practice was that they wouldn't be issuing NTAs until the expiration of the appeals and motions period. So what I took from that was that they were that they wouldn't be issuing NTAs if there was a pending motion either. I think we'll see in the next few months or the next year how things actually play out, but that was my interpretation.
So then just to kind of bottom line it, the main thing it sounds like that you could be losing, and I know we're going to come back to this, is that they could say, well, we're not going to keep giving you work authorization because it's just a motion, it's not an appeal. Is that right?
Right.
Okay.
Yeah. And also just as a note, in the files section underneath the chat box, there is the NTA memo Q&A PDF. That is USCIS's Q&A from the September stakeholder meeting. So in case anybody didn't have a chance to attend that or to look over the Q&A previously, it's there. Okay. Next up, motions to reconsider. So these are quite similar to the motions to reopen. The difference is that instead of showing new facts, you need to show that there was an error in the underlying denial. So you are not showing new evidence, and in fact, the adjudicator will not consider new evidence for purposes of a motion to reconsider. You're essentially saying that the record, your submission, was sufficient in and of itself, and that they made a mistake in their consideration of the evidence and the law in their denial. But otherwise, it is essentially the same in terms of the nitty-gritty as a motion to reopen.
So it sounds like you could do, going back to the combo, is that you could basically have kind of a plan, even if you think they're wrong on the law, right? That could be your plan A. Motion to reconsider, you're wrong on the law, but we're still going to supply more facts even though we don't think that your request for the facts are legally required, right? So it's kind of a combo motion to reopen, reconsider?
Yes, you could do both. And you can also do both in an appeal too, right? So there's no limit to the evidence that you can supply in an appeal and the arguments that you can raise in an appeal. It's just that the motions where for a motion to reopen, that they require you to provide new facts, and a motion to reconsider that they require you to show error. But because you can file both a motion to reconsider and reopen at the same time on the same form, that you can raise all those arguments at the same time.
If I could just make another paradigm shift point here, is I think that, again, in the past, we often thought we could get many things fixed at Vermont through motions to reopen. I think, again, we want to be more aggressive on challenging them when they're inaccurately applying the law. So you'll probably see us asking you to make legal arguments that they're wrong on the law, and then if you want to supply more facts, that's up to you, because you have to do what you need to do for your client.
I see a question from Melissa. If an appeal is pending, can the victim request an EAD while the appeal is pending? What's the legal authority? Okay, so the issue with appeals is that if you were already eligible for work authorization based on, for example, having U status, and then you applied for your adjustment of status, you maintained your work authorization, and then your adjustment was denied. If you file an appeal while the appeal is pending, you maintain your U status because the case is not considered closed at that point. And so because you're in U status and because your 45 is technically still pending, that's why you're able to maintain your work authorization. If you did not have any underlying eligibility for work authorization, then you would not be eligible for an EAD while the appeal is pending. The fact of an appeal pending in and of itself is not going to make somebody work authorization eligible. Hopefully that clears it up a little bit. Okay. Moving on to deadlines. So there is a deadline for filing an appeal or a motion to reopen or reconsider. Your denial notice should say what the deadline is. These notices are really always mailed, and so that means that your deadline is going to be 33 days from the postmark on the date of the denial. And so save your envelopes, because what we've seen often is that the date of the denial notice could be, January 1st. but the date of the postmark could be January 10th. And so you would need to know when the denial notice was actually sent in order to calculate your deadline for filing the 290B. And for the 290B deadline, USCIS must receive the 290B by that date, right? So it's not the date that you send it out, but rather the date that USCIS receives it. And so obviously don't wait till the last minute to file, and always send it with a trackable delivery method, right? So that you can confirm that the 290B was received by USCIS timely, because sometimes they lose things, and so you would want to be able to have a tracking mechanism so that you can fight back if they say that they didn't get something on time and you know that they did. Okay. All right. So let's practice with this deadline calculation. So let's say you got the denial of your client's 485 on November 2nd. So that's when you received it. And then the date on the denial notice is October 24th, but the postmark on the envelope is October 30th. So keeping in mind that you've got 33 days to get your 290B into USCIS, what's your deadline? And you can use this little time and date calculator to calculate it if you don't want to count it out. And here are your choices. All right. So it looks like we've got a range of answers here. This is one of those rare circumstances when we actually have an objective answer to one of our poll questions. And the answer here is going to be Monday, December 3rd. And why is that? So if we go back to the scenario, let's see how we end this poll. Alicia, is it? Thank you. Great. All right. So we are counting 33 days from the postmark date. The reason for this is that the deadline is 33 days when the denial decision was mailed, right, which we know it was in this situation, and it's counted from the date that DHS effected service of the denial notice. The date that they effect service is the date that they send it out. So that's going to be your postmark date. And so that's what we're counting from October 30th instead of October 2nd, which is when they wrote their denial notice, and also not November 2nd, because October 24th, sorry, and also not November 2nd because it doesn't actually matter when you received it. What matters is when they sent it. And so if we count out 33 days from October 30th, day one is going to be October 31st, right? So you've got October 31st, and you just keep counting every day until you get to the 33-day mark. The 33-day mark is actually Sunday, December 2nd. But if the deadline falls on a weekend or a holiday, then it's bumped to the next working day, which is going to be Monday, December 3rd, right? So you have until Monday, December 3rd to get your 290B into USCIS.
So,
okay.
Amy, is that link on the prior?
Gail, you're cutting out again. I can't hear you. If you're referring to the questions in the chat, I see them. So the citation to use the postmark date, when we get to the next section, when Gail's up, I'll put the citations into the chat box for everybody. They're from the regulations. And the regulations speak to when service is effectuated and what the deadline is from there. Okay. The other thing to point out is that sometimes on your denial notices, it'll give you an actual date when the 290B is due. If they give you an actual date, I would comply with that date. If they're telling you a different deadline, I would comply with that. But when we get to the next section, when Gail's up, I will put the citations in for the postmark date and all of that. Okay. All right. Now, what if you miss the deadline, right? So there are all kinds of reasons why you could have missed the deadline. We'll be talking about fee waiver issues just in a couple moments. But sometimes deadlines are missed, right? And so what do you do? So if you're filing a motion, you can file a separate motion called a motion to accept late filing, right, to accompany your motion to reopen or your motion to reconsider. The problem with appeals is that there is no regulatory provision for the AAO to accept late appeals. And so generally the position of the AAO is that they don't accept late appeals.
You're cutting in.
Is this better?
Amy, you sound great to me.
Okay. So what part did I cut out at? I'll just repeat the part about appeals. And so the problem with appeals is that there's no regulatory provision for the AAO to accept late appeals. And so we have some suggestions for arguments to try to get them to accept late appeals when the situation calls for it. But generally speaking, the position of the AAO is that they don't accept late appeals. However, there is a regulatory provision where if the late filed appeal otherwise meets the requirements for a motion, so if it establishes new facts for a motion to reopen, or if you're showing an error for a motion to reconsider, right? If you're making those same arguments in your appeal, then the Service Center can treat a late filed appeal as a motion to reopen or reconsider. But you should still include the arguments for the acceptance of the late filing. Okay. And the reason, and we would recommend that if you have a late filed appeal where you think you have good arguments as to why the AAO should accept it anyway, that you just make those arguments. You don't have anything to lose by asking the AAO to accept the late appeal. Because even if they don't, they should be treating it as a motion to reopen or reconsider anyway, even if they don't agree with you. All right. And then if you're filing with some arguments for having missed a deadline, for purposes of the motion, a late filed motion, you're required to show that the delay was reasonable and beyond the applicant's control, right? And so what are some reasons why the delay might have been reasonable and beyond the applicant's control? A classic one is ineffective assistance of counsel. So if the person was represented and the attorney just flat out missed the deadline, IAC is a potential argument there. Another one that could be coming up more often these days is USCIS error. So let's say you filed a 290B with a fee waiver. The fee waiver was complete. It complied with all the requirements. You showed all the evidence to show that your client was unable to pay the fee, but USCIS denied your fee waiver anyway, and you think this is erroneous. You could make an argument there that it was USCIS error in denying your fee waiver that caused the delay for the missed deadline. And I'm going to open up here in the chat box. Do people have other suggestions for reasons why you might be able to justify a missed deadline for 290B? Great. So Stephanie suggests childbirth, death in the family, hospitalization, right? There are a lot of other contexts in immigration where there could be extraordinary circumstances that are used in these kinds of circumstances or these kinds of situations, to include, severe illness or death of an immediate family member, severe illness of the applicant herself, other things like that, that if they're a factor in your case would be something to raise as an argument. Okay, fee waivers. So we've been hearing from a lot of people in the field that fee waivers are becoming more and more of an issue in the 290B context, as well as really any other kind of application with USCIS. And so we have some ideas on different scenarios and how they could play out and arguments to raise here. I would say the general caveat to all of this is that you can comply with all of the requirements and submit really great evidence, and we're still seeing really strong fee waivers getting denied. So it's an ongoing battle, and we are aware of it. So as a general guideline, the 290B does have a fee of $675. There is a fee waiver available for the 290B. And then the problem is that if you're filing a fee waiver with the 290B, if the fee waiver is denied, then your 290B is going to be rejected for failure to pay the fee. And if you're not able to refile the 290B before your deadline, there's no guarantee that USCIS is going to consider your 290B as timely filed, right, if they receive it after the deadline. So it's a really important consideration, and I know it's a big decision for a lot of people who really can't afford the fees, right, what they're going to do and how they're going to weigh the risks in that situation. So we have a little hypo here. Imagine that your client's I-360 has been denied for lack of good faith marriage. You have a new evidence of good faith marriage, and you also think that CIS didn't properly apply the any credible evidence principle. And so you filed an appeal, and you filed it with a fee waiver request. And USCIS denied the fee waiver, but you didn't receive the denial of the fee waiver and the rejected 290B until after the 290B deadline had already passed. So in that situation, what would you do? And so our options are file the late appeal, file a late motion to reconsider to the service center, file a late motion to reopen to the service center, and file a late motion to reconsider and reopen to the AAO. All right. Just give it one more minute. Looks like some more responses are still coming in. Is that Gail? Is that Gail? I can't hear you.
Yeah, Gail, I'm gonna try to call you back. We can't hear you. So can you hang up and I'll call you back. Thank you.
All right. So while we're getting Gail back on, let's go over the poll. So here, let's walk through these options one by one. And so the thing about filing a late appeal is, as we talked about earlier, there is actually no regulatory provision that allows the AAO to accept a late appeal. But there's nothing to lose, right? And so you might as well just raise the argument and ask them to do it. One other suggestion that we've been talking about is asking USCIS to reissue the denial notice so that would restart your appeals period. We don't know if this has worked. We're really trying everything at this point because this is such a big problem. And so it's one of those things where you just try every argument you possibly can and just see what happens. And then as I mentioned earlier, as long as your appeal satisfies the requirements for a motion to reopen or a motion to reconsider, then even if they don't accept the appeal because it's untimely, they should still consider it as a motion to reopen or reconsider. The thing to keep in mind is, Gail, are you back on?
Yes, can you hear me? Okay.
Yeah.
So two questions, the interrelations between the fee waiver and the AAO. Who decides the fee waiver request if you're appealing to the AAO? Is it the AAO or Vermont? Do we know?
It appears to be Vermont. The decisions are coming from Vermont, at least the ones that we've seen.
Okay. But you don't think we can challenge, like, say what you're saying is we think they're actually applying the standard wrong. You don't think we can challenge that in an appeal to the AAO?
Well, there's no appeal of a fee waiver denial, which, we might not agree with, but I think that we'd be hard-pressed to convince the AAO that they have jurisdiction over a fee waiver denial in and of itself. So it's a tricky situation.
Right.
So Evangeline is saying, sorry, Gail, go ahead.
I just want to make a practice. I think this is an emerging issue we're doing a lot of work on. I do think it's worth us somehow raising this to the AAO because this does to me seem like a legal argument, right? If they're doing, I think that it's a regulatory prohibition against review at the AAO of fee waiver denials, and we could argue, well, that can only mean the discretion part of it because we have to have review of, an inaccurate application of the standard. But as Amy's saying right now, that's not how they're interpreting it. But let's keep that in mind because I think there's a lot of arguments we need to be pushing on these fee waiver denials.
Yeah. And I see here in the chat box that Evangeline is saying that they have requested a redated decision in the past, and that's actually worked. So that is great. If it's working, then I would definitely keep asking for that, and hopefully they'll continue to do it. Because that would actually solve your timeliness problem. If they're willing to redate the decision, it'll restart your appeals and motions period. Okay. And then our next option was file a late motion to reconsider, also late motion to reopen to the service center. So these are viable options. You can do it. This is probably more strictly in line with the regulations, but at the same time, there's really nothing to lose by filing the late appeal. So that's why we recommend doing that. And then in terms of filing the late motion to the AAO, so the reason why you technically can't do that is because if the underlying decision was denied by the service center, only the service center has jurisdiction over the motion. The AAO will only have jurisdiction over a motion to reopen or a motion to reconsider if the underlying decision was made by the AAO. And in practical terms, that really means that the only time that you're going to be able to file a late motion to file a motion to reconsider or reopen to the AAO is going to be when you are filing a motion on an appeal that was denied by the AAO. Because otherwise, the underlying denial is always going to be coming from a service center. And so they're the ones who are going to have jurisdiction over the motion.
So just backing up a second, it sounds like one of the things we might suggest with these fee waiver issues is do a motion to reconsider if we think that they applied the standard incorrectly on the fee waiver and then denied, so that you didn't have time to actually file another motion or appeal, is to do a motion to reconsider on them inaccurately applying the standard fee waivers. And this goes back to the arguments you were suggesting earlier that this is the government's fault, so your client shouldn't suffer from that, and they should either, whatever all these ameliorative suggestions, we can be creative about, either, nunc-pro-tunc it back to a date that allows you to still file or extend the deadline for filing, because the deadline for filing is purely regulatory, right? So we could also argue that it's contrary to the goals of the statute if this purely regulatory deadline is preventing all these survivors Congress intended to to get status from actually being able to pursue their claims.
Right. And I think the other thing that we'll keep getting back to as we're talking about all of these issues that we're having with fee waivers, with discretionary denial, with all of this, is that ultimately some of the best arguments are going to be more persuasive to a body that is not USCIS. And so we'll be talking a little bit about AAO or APA claims later on. So it's something to keep in mind. All right. Alicia, can we take down the poll? Great, thank you. Okay, so all right, let's go back to the substantive issues in this hypo, right? And so aside from the timing, right, of this filing and whether you're going to file an appeal or a motion to reconsider or reopen, what are the errors that you're identifying here, right? So your I-360 was denied for lack of good faith marriage. You do have additional evidence of good faith marriage, but you also think that USCIS didn't apply the any credible evidence principle, right? All right, so this is in line with some of the hypos that we saw earlier with the, especially in the VAWA context. If you are seeing that they didn't apply the any credible evidence principle, then that could be the basis for a motion to reconsider, right? That would be an error of law or an error of fact applied to the law, where you're saying that even based on the submission as it was filed, even without the additional evidence of good faith marriage, your client still met her burden and her I-360 should still have been approved, right? And so you can make those arguments to support a motion to reconsider. For the motion to reopen, you would be using the additional evidence that you have for the good faith marriage. Okay. And then a couple last bits of nitty-gritty here. And so we would always recommend going to the uscis.gov website for the most up-to-date filing addresses and the most up-to-date instructions on any of this. The 290B is going to be filed with the service center that issued the denial. And then if it's an appeal, then the service center will forward the 290B to the AAO, whereas if it's a motion, then the service center will adjudicate it. Okay? Now, what if you have more than one denial? So point of clarification here, Gail and I were going back and forth about this actually before our webinar today. Essentially, it depends on which form was denied on the merits. So, for example, if you had a U visa where the I-918 was denied because USCIS is saying that your client was not helpful, and because the 918 was denied on the merits, they also went ahead and denied your I-192. So in that case, you would be filing an appeal or a motion. Generally, we recommend an appeal on the I-918. And then historically, the practice at USCIS has been that if USCIS grants your appeal of the 918 denial, then they would remand the 192 back to the service center for reconsideration of that denial at the same time. And so you wouldn't have to file a separate 290B on each of the ancillary forms. All right. And then how do you minimize cost to your client? Because obviously if there are multiple forms that are being denied, we wouldn't want to have to file 290Bs on each of them because, if it's possible, because there are fees on all of them, right? And so especially for something like a 765, there wouldn't be any reason to need to file a 290B on that. In theory, if you look at the example that I was talking about earlier, if the 918 was denied on the merits and then you filed the appeal of that and you won, then the service center should be reconsidering reconsidering all of the other ancillary applications that were denied as a result of the 918 denial. And in theory, you shouldn't have to file 290Bs for that. And hopefully you wouldn't have to file a 765 either if they remand for reconsideration for all of the ancillary forms that were denied. That should take care of it. For the 765, though, you may, if they don't, then you may just want to refile the 765. It's probably your fastest solution. All right, and Gail, you are up.
Yeah, I think we probably covered a lot of this, but so this is a review. And again, I think as we see how the different parts of the agency respond to motions versus appeals, we may change on what the pros and cons are in different situations, but to summarize, you're going to have to choose, right, initially. Are you going to do a motion back to the part of the agency that you think made the wrong decision, or are you going to appeal directly to the part of the agency that could independently review it? One thing to know, as we mentioned at the beginning, is that even if your appeal is denied at the AAO, you can file a motion to reopen or reconsider with them. So I think at this moment, this is going to be most relevant to you, to those of you who have appeals at the AAO now that we didn't know about and haven't helped you with, and may want to start helping you. You know, there may be additional arguments we can think about that you could use if they deny to do a motion to reconsider, motion to reopen. I think you'll, well, this is completely speculative at this point. I don't think so far we've seen a lot of motions to reconsider, reopen at the AAO, and I think we've probably, to the degree there have been, we haven't seen a lot of reconsideration or reopening at the AAO. But that doesn't mean we shouldn't push we need to keep pushing the agency to review what it's doing. And then back down at the lower level, if you've done a motion to reopen or reconsider at the Vermont Service Center and it's denied, then you can also appeal that motion to the AAO. At least up until now, again, it's not been a lot of cases, but we have seen even in that procedural posture, the AAO has reviewed the merits. If you're familiar, however, with cases and proceedings and federal court work, you know that they don't actually have to review the merits. They could just review whether the agency properly denied the motion to reopen or reconsider. So let's say they deny it purely on a date problem. They could just say, yeah, you're right, they're right, you didn't file it on time, bye. So it's really important to think about that when you're thinking about doing your motions to reopen and reconsider and the appeals. Let's see. So pros and cons. Pros, again, with the appeals, as the case remains open, we were trying to pin down what that actually means right now. It seems like the main benefit is you can continue your work authorization. We think that at this point, the NTA implementation will apply, that they'll hold off even if you have a motion pending, not an appeal. We need to keep our eyes open for that because we wouldn't have you all doing motions and then suddenly you're getting NTAs issued because you framed it as a motion instead of an appeal. Amy, we were discussing this. In the past, Vermont has said that they will review your appeal to see if they should take it as a motion to reopen or reconsider. It's not clear to me they're actually doing that anymore. I have the feeling at this point you're going to have to fish or cut bait. You can't assume that if you file an appeal, it will also be considered a motion at the Vermont Service Center. Having said that, I also am seeing far less fruit born of filing motions to reopen or reconsider with Vermont. In the beginning, we actually got them to look at cases a lot and to basically send them back for further adjudication. I have not seen that happen in basically the past 5 years. If any of you have, I'd love to see it, to see what context it was in. But it's very hard, and in general, it's very hard to get the same adjudicator to look at the case they did and say, whoops, I made a mistake, right? That just doesn't happen that often. So what we really need to be seeking now is review by an independent adjudicator, whether that's in the agency itself at the AAO or, as Amy has mentioned, maybe beyond. So not all, the problem with going to the AAO, as some of you know, is that by regulation, not statute, the AAO is prohibited from reviewing the discretionary denial of the 192 waivers. So part of what we have on our website are legal arguments that we think you should be including in all of your waiver, your I-192 arguments now. Remember, create that record thing we were talking about, to Vermont, and then we take those to the AAO. People have been doing that. The AAO has been ignoring it, but that doesn't mean that eventually they won't pay attention. The basic argument is that Vermont has never articulated and really implemented the D14 waiver, which is a special waiver that Congress created for these. What they have been doing is essentially glomming on the case law on D3 waivers to D14 waivers, and that's not lawful. That's an Administrative Procedures Act violation. That's something that that's a legal issue the AAO should be able to review, and that's all written up. You can cut and paste it and put it into that, and we want to keep hammering the AAO with that argument until they don't even mention it in the denials they're saying. They're just saying, oh, we can't review waiver denials, and except when your argument is that, say, they said it was a crime of moral turpitude and it's not. Then they will look at that, whether they're applying the wrong grounds of inadmissibility. But we need to get them to do their job, which is to review all legal arguments. Again, you have the same problem if you lose at the AAO and then you want them to reopen. It's the same people doing it. But I do still have hope that, first of all, the people at the AAO are all lawyers, which is definitely not true at the Vermont Service Center, so you know, which is one of the reasons we have suggested in the past that doing a lot of legal briefs to them is kind of pointless because they'll just go right over their head. But I think now it's that create the record thing, and then you can also do it an argument that's accessible to people who aren't lawyers. The same adjudicator is unlikely to review what they do. I think it's still more likely at the AAO. I think it's even more likely if you have an amicus brief from us that's also signed on to by the domestic violence community. That seems to get their attention. But we are also starting to explore, and we'll come to this later, what to do beyond the AAO. Okay, so here are the motions to reopen, pros and cons, which is kind of the flip side, I guess, of what we just discussed. Everything's open, eligible for a motion to reopen or reconsider. I don't know, Amy, whether you think that motion to reconsider is more likely to fly since that's purely legal, or do you think a motion to reopen where you supply more evidence to them that they want is more likely to fly? Do you have any sense of that at this point?
I think it depends how clear-cut it is. It's so case by case. I think for a motion to reconsider where it was really clear legal error, you might have more success with that. But if it's a question of interpretation and you're interpreting something in a different way from the agency, then I don't see that as being more likely to succeed versus an appeal.
Right. And this is where we put the plug in for our ability to communicate with the people who make policy in the agency. They do not respond to us now, but it's clear that they are looking at what we're sending them still. So if those of you who have never used what we call our intervention system should use it, because what we do is we help raise your issues to the heads of the Vermont Service Center and to the people who make policy in D.C. for humanitarian relief. And although they won't tell us what the results of that are, it does seem in many cases to get further scrutiny. And the only way we know that is you contact us and say, suddenly I got my 485 granted or something like that. So let us help you, basically. And let us help you early and often. Because, again, part of what's helpful about us having the system is that it's not just us helping you with the individual cases. It helps us see kind of system problems as they emerge so that we can raise those to the level. Like it's a training issue. You seem to have adjudicators who don't understand the standard or whatever. So it's not just an individual case issue. And I think that's one reason that we've been successful is that we have no investment in your particular case. We're not saying to them, you should grant this case. We're saying we think this is a problem in the analysis and we're concerned that this is being applied to other people, like what's happening to pro se applicants who are making this argument or attorneys who don't know to challenge this. So that gets their attention and maybe helps still. And it's still worth doing, I think. We've already discussed the cons with the whole system is that you have the same adjudicator re-adjudicating it, but this is where the intervention system kind of helps bypass that. Is that we do flag it for people who otherwise would not probably be looking at your individual case. It would probably go back to a supervisor or back to the original adjudicator. And this way someone else is looking at it. We don't know what they'll do, but at least someone else is looking at it. Okay, I think we'll move on unless there's something else here, Amy, you think worth highlighting, or is there there's a lot of stuff going on in the chat. Do you want to share any of that now, or let's do this
I was just
poll,
putting in I was just putting in the sites that people have been asking for earlier.
Oh, great. Okay, all right. Here's another poll. So your U principle timely.
Gail, you're cutting out again. We still can't hear you. Okay, so I'm going to be taking over. We just have a couple slides left anyway. Sorry about all the technical difficulties we've had today, everybody. All right, so I think this might be our last poll. Your U1 client timely filed her I-45, which was denied on discretion. She doesn't qualify for a fee waiver, but she can only afford to file 1290B. So she's got to choose between an appeal or a motion. And her other consideration is that she is worried about losing her job at the airport. And so, would you file an appeal or a motion? Great. So yes, we would file an appeal. And why would we do that? So in addition to all the considerations about wanting a different adjudicator, knowing that the AAO is generally better at understanding legal arguments, there's also the consideration of your client. Alicia, if we could take down the poll so we could see the slide better, that would be great. There's the other consideration that your client is worried about losing her job, right? And so if we recall for the U1s, if you file an appeal, the case technically remains open while the appeal is pending, and so she would retain her work authorization, her use status for a little bit longer while the appeal is being adjudicated. And hopefully, eventually, it would be granted, right? And so for a number of reasons, we would definitely be looking at filing an appeal in this situation. All right, next up. So let's say your appeal or your motion was denied. Now what do you do? So if your appeal was dismissed by the AAO, you can file a motion to reopen or reconsider that appeal. And it's the AAO who would be adjudicating that motion. Or conversely, if you first filed a motion with the service center and they denied your motion, then you would be able to appeal that denial of the motion. Okay, and then that appeal would go up to the AAO. So whichever way you do it, you would be either able to file a motion on the denied appeal, or you can file an appeal on the denied motion. Okay? In either of these situations, you're filing a new I-290B with a new fee or new fee waiver. And the caveat for motions to reopen is that there are certain case types that are not appealable, right? So like we mentioned earlier that fee waivers are not appealable. Also, discretionary denials of I-192s are not appealable by regulation. And so if the underlying case type was not appealable, and so that's why you filed the motion, if your motion was denied, then you still wouldn't be able to file an appeal. Okay, but if your underlying case type was appealable, let's say it was like a 485, 918, then even if you filed a motion first, you would still be able to file an appeal if the motion were denied. Another option, instead of doing those things, would be to refile the application. There are times when this makes sense, but a couple of things to keep in mind. Obviously, you're going to lose your filing date with the long backlogs that we're seeing for every type of application these days. This means a significant amount that would be added to your client's wait time. If it's a U visa, you would need a new certification, and then also you might have age-out concerns. Okay, so the derivatives ages might have been protected while the initial application was pending, but if you're refiling, then that age-out protection doesn't carry over to the new application. Okay, so I'm seeing a question about this from Stephanie. The AAO cannot review discretionary denial of I-192, but it can, I assume you want to say review other discretionary decisions. Yes, so for example, U adjustments. So I-45s based on 245M are also discretionary decisions. The AAO can review appeals of 45 denials for U adjustments, right? So limits on the AAO's jurisdiction are typically going to be spelled out in the regulations. So we would refer back to there to know whether or not the AAO will determine whether they have jurisdiction or not. And as Gail is pointing out, there are times that we disagree with them about whether or not they should be able to have jurisdiction. But the AAO tends to follow the regulations quite strictly. Okay. Okay. Other options. So in addition to refiling, in addition to filing a new appeal or a motion, what else can you do here? There are certain case types over which the Executive Office for Immigration Review or the immigration courts and the Board of Immigration Appeals could have jurisdiction. So you do need to check to make sure that EOIR would have jurisdiction over the case type that that's of concern. We've spelled out a couple here, but this is a little bit more limited, right? So generally speaking for U's, for the most part, unless you're dealing with a 212D3 waiver for inadmissibility, EOIR generally does not have jurisdiction. It's a little bit different for VAWAs. We think that the BIA should have jurisdiction over I-360 VAWA self-petitions. We haven't actually seen this in practice, but based on the regulations, we think that this should be correct. So if you guys are doing a BIA appeal of an I-360 denial, we definitely would be interested in helping you with that and thinking through the strategy and the arguments for that. Okay. And then we would also encourage you to identify any relief to pursue if the NTA is issued, right? Thinking back to the beginning of the webinar today, if your case is denied, it's possible that your client will be NTA'd, that she will go into removal proceedings. So it's important to think about what relief she would be able to apply for before the immigration judge as well. All right, some other options. The Ombudsman is an option. We have a link there to their case assistance website. You would have to submit an online form, and then they can help you to intervene with USCIS. Their protocol is that you do need to try to resolve whatever issue it is with USCIS first. I think that we've been hearing a lot of reports from the field that Vermont is becoming less responsive to the hotline. And so going to the Ombudsman could be a strong option because at the very least you're going to get some kind of response. It's going to take a while. It can take a couple months. And you won't necessarily get the answer that you want, but you might hear something. Your chances of hearing something could be a little bit higher with the Ombudsman. And another option is asking for congressional intervention. This is sometimes helpful, sometimes less helpful, but it's worth a shot. You're not going to lose anything. And so for this, you would determine who your client's representative or senators are for where your client lives, and then follow their protocols. There's typically a privacy release form that your client's going to have to sign. You submit it to the congressperson's constituent relations people, and then they will contact USCIS on your client's behalf and let you know what USCIS says. And sometimes this can really light a fire under CIS to get something done, and other times it's less effective. But either way, there's nothing to lose here. All right, next up. As we mentioned earlier, there are going to be times when you're just not going to get an appropriate response from USCIS. There are times when we think that USCIS's interpretation of the law or even the regulations is incorrect. There are times that we think that they're, in Gail's words, glomming on extra requirements, extra statutory requirements. And so it can be difficult to convince USCIS that they are interpreting the law incorrectly. And so sometimes you need to go outside the USCIS system. The other resort can be the Administrative Procedures Act through federal litigation. And so we're only going to be talking about this very, very briefly today. This is worth a whole class in and of itself. But generally speaking, the claims that you would bring up under the APA will include things like suffering a legal wrong due to agency action, or that the person has been adversely affected by agency action, federal action that's arbitrary, unconstitutional, or contrary to statute, and then also if the agency action was arbitrary and capricious, right? And so if you are thinking about an APA suit or anything like that, please reach out to us. And it's something that we would be interested in talking with you about and giving you some pointers on to think about arguments and how to set things up for APA. All right. And then what if all else fails? So as I said earlier, assess your client for other forms of relief, right? There are times when even when we think that we're right, that in the end we still lose. And so especially if your client is in removal proceedings, then we would recommend assessing your client from the beginning for eligibility for asylum, withholding, CAT, and cancellation, both VAWA cancellation and tenure cancellation. Your client could also be eligible for other forms of relief before USCIS, such as a family petition. Could also be looking at employment petitions for some people. And so it's a time to think creatively about all the forms of relief that your client could possibly be eligible for in case their primary application falls through. All right. So our next webinar is going to be December 3rd. It's going to be case rounds on U's and VAWAs. So we've tried to leave time for a lot of questions from the field, but we're also planning to go a little bit more in depth into some suggestions and arguments for combating these fee waiver denials, among a couple of other ongoing issues that we're seeing in the past couple months. In the meantime, please feel free to reach out to us for individual technical assistance. As OVW grantees, you are eligible for free TA. And if you'd like to get onto our listservs or have other questions for us, you can contact us at any of these email addresses on the screen. And we have a few more minutes, so let me see if there are some questions that I missed or if there are new questions. So let's see here. Okay, yeah, if anybody has super case-specific questions, it's best to submit that via TA so that we can help you on an individual basis. Okay, so I'm seeing a question here from Evangeline about filing supplemental materials. So the question is, for appeals, briefs and all evidence must be filed with the 290B, so within 30 or 33 days, for motions to reopen or reconsider. The form says that you can file the brief or evidence later. How much time do you then have to file? So this is actually contrary to my understanding of the 290B form, because I'm pretty sure you get extra time to file the brief for an appeal and not for the motion. Yeah. So if you're looking at the 290B form, if you're filing an appeal, you have an option to submit your brief and or additional evidence within 30 calendar days of filing the appeal. So that's your time frame. For a motion to reopen or a motion to reconsider, for a motion to reopen, your additional evidence would need to be attached to your motion. It's due at the same time. And then for both motions to reopen and a motion to reconsider, the brief is due at the same time as the 290B. And this is all coming from the form. All right, let me see other questions here. So from Lori, can we go back to the NTA discussion? Is it entirely clear that we won't be receiving RFEs on any of these matters? My understanding from USCIS is that some RFEs may still be issued. So I agree with you that some RFEs may still be issued. What the RFE memo says is that they're going to be, that the adjudicators have discretion to issue a straight denial if the initial required evidence is not submitted. Right? And so if you look at the USCIS website, for each page specific for each type of form, they have a checklist on there that tells you what USCIS considers to be the initial required evidence on each of those forms. If you were at our RFE webinar last month, you'll know that some of the checklists are a bit incomplete, and so we wouldn't recommend relying solely on those checklists. You always want to follow the form instructions and the regulations and the statute when you're doing your filings. But the idea is that based on the memos, they can, but not necessarily must, issue straight denials if the initial required evidence is not submitted, but they would still be issuing RFUs on other issues. So for anything that's not initial required evidence. Okay. And then from Lorena, you may have answered this concern. What is with the recent denials of fee waivers for U visa I-192 and I-765? So the fee waiver denials seem to be more general, I would say, even than 192s and 765s. As Gail says, there are some documents on our website that address some practice pointers that we have on this, and then we're also going to be talking in more detail about fee waiver denials and some arguments, suggested arguments, and practice pointers at our next webinar on December 3rd. In short, we've seen a lot of fee waiver denials lately for all different kinds of reasons, and there are a number of different arguments that we would raise for those kinds of things. I would say the takeaway is probably if you're filing a fee waiver, file your application as soon as possible because you don't actually know what's going to happen with your fee waiver. Okay, so I'm not seeing any other questions. It doesn't look like anybody's typing. So I think that concludes our webinar today. Thank you so much, all of you, for attending and bearing with us and participating so actively in this. We're sorry about the technical difficulties that we've had today. Hopefully we'll be able to iron them out before the next one. If you do have any other issues that are coming up, questions that you're thinking about, please send us some TA. We love getting inquiries and requests for TA from people. If not, then we will see you hopefully at our next webinar on December 3rd. Thanks, everybody, and thanks, Alicia.